Good afternoon. Today is Monday, May 5th, 2025. It is 1 p.m., and I'd like to call to order this meeting of the Tennessee State Board of Accountancy. Notice of the May committee meetings of the Tennessee State Board of Accountancy, including date, time, and location, has been properly noticed, and a copy of the agenda was posted to the Board of Accountancy website on Tuesday, April 29th, 2025. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comments period will need to sign in on the provided sign-in sheet or by placing their name in the chat box online. The public comment period will take place at the end of the meeting. Today's meeting consists of the board's 4 committees and their various agenda items. The full board meeting will take place tomorrow, May 6th, beginning at 8:30 a.m. And I would like to welcome any visitors or members of the public. I don't see any in the room, but there could be some online, Karen. I don't know if any members of the public have joined us.
No, sir, not yet.
Okay, thank you. And I would also remind board members to please turn on your microphones when speaking and turn them off when finished. And just as a reminder, only 4 of the mics are operational at any given time. Then one other thing I will add to this, I believe board member Brad Buchanan is joining us virtually. Is that correct, Karen?
Yes, sir.
Okay, thank you.
We're
And
working
then
on
one of our board positions has not been filled, the one that Mike Parton held briefly. That position has not been filled, and then I think David Crenshaw cannot be with us today. So I think there are 8 of us in the room, board members. So welcome, and at this time, I will turn the meeting over to Licensing Chair Pamela Church.
Thank you. We have 4 items. The first one is Gabriel Brin, who has requested us to consider a 2-month extension on his reg and audit scores from an expiration date of 6/30/25 to 8/31/25. He noted that his doctor had provided documentation affirming that he is under treatment for a medical disorder that has prevented him from being able to prepare for the last part appropriately. His audit and reg scores were previously approved for an extension under the Credit Relief Initiative program, and the rationale he has explained seems to be in keeping with our policy on extension, in my view. So I do not have a problem with this, but I'd like to open it up for discussion. Any input? Call for the question. Do we do this by voice or by roll call?
I believe we can do it by voice. Mr. Buchanan hasn't joined us yet.
Okay. All in favor? Aye. Opposed?
Something went wrong.
Something
Please try
went-
again.
My iPad's talking to me. Siri. All right. The second one is Michael Montgomery, who has requested an extension of Reg and BEC from an expiration date of 6/30/25 to 12/31/25. And his is a little different from what we've seen. He noted that his intention upon graduating from his Master of Accountancy program in May 2020, and note that that was right in the middle of COVID, was to accept a role with an accounting firm and pursue CPA license. But while sitting, the start date with the accounting firm where he was had an offer, the start date was furloughed, so he began working as an investment banker And the experience that he obtained in that position did not qualify toward becoming a CPA. So he ceased taking CPA. So he abandoned the idea of becoming a CPA, and has since left investment banking and has taken a position working with the CPA, and his work there would count toward licensure. So he began studying for and taking the remaining sections of the exam. In January 2025, he sat for FAR April the 9th and is scheduled for audit June the 2nd. And he knows that the wording of the regulation is that we grant extensions for undue hardship. I've usually said extenuating factors, and usually is something beyond the candidate's control. But he requests that we consider his furlough as beyond his control. And just adding my own opinion, I think COVID might be considered a factor here too. Anyway, so Reg and BEC were previously approved for extension under the board's credit relief program, and his rationale, as he outlined it, seems to be consistent with that if we consider this situation to be in line with our regulations. Is there discussion? Call for the question. All in favor of granting this extension, please say aye. Aye. Opposed? All right, the third one. Come on. This is Samuel Lewis, who has requested that the board consider an extension of Reg from an expiration date of 8/6/2025, which of course is in the future, to 12/31/25. He contacted the board in March requesting this extension. Notably, he's passed TCP with an expiration date of 12/27. He suffered from a medical condition that began in June 2023 and lasted through January 2025. Managing the condition impacted his ability to appropriately prepare for the last two sections of the CPA exam, and he provided medical documentation from his doctor and hospital visits during this period. So the only thing unusual to me is that this is in the future, but he is trying to plan his taking of the exam and making sure he has time. So is there a discussion on that? All right, call for the question. All in favor? Aye. Opposed? Okay. And the last one, again, is a little bit different.
Dr. Church, Mr. Buchanan has joined us.
Okay, thank you. So we'll need to do roll call. Okay. Simplice Zariga has requested that the board consider acceptance of his foreign transcription evaluation completed by WES as a qualification for licensure in Tennessee. And I don't know if we've dealt with this in the last few meetings, but World Education Services evaluated Mr. Zariga's transcripts. These are foreign international transcripts that have to go through a service like this. His bachelor's and master's degrees from Ivory Coast on May the 16th. Note the date, 2007, when he was approved to start taking the exam in 2008. He has since passed all 4 sections, with the final section being passed January 25th, 2025. And if you look at his scores, he has taken the exam, how many times did you say? He's taken parts, was it 19?
I think it was about 19
I think it was
times.
19 times. He has been very diligent in sitting for the exam. It has not been because he had just postponed. But what happened was that let me just note, it says, applicants who obtain their education outside the United States must have that education evaluated by a credential evaluation service approved by the board. The purpose is to compare the education they received to the education received at an accredited institution in the United States. But at the May 4th, 2021 meeting, our board voted to withdraw approval of WES reports effective August 1st, 2021. NASBA, the board staff, had concerns regarding how they treated education received in India, and specifically WES found India's 3-year degree program to be equivalent to a 4-year degree program. The treatment was not consistent with other evaluators or the board's rules. So it says the transcripts as reviewed by WES and submitted by him indicate that his bachelor's degree was completed in 3 years. His transcript does indicate, however, that he met the 150-hour requirement for licensure. So this is unusual or noteworthy in that when his transcripts were evaluated, WES was an appropriate provider. So just to interject my opinion, I think that we approved him and he acted on that approval. But I will open it up for discussion.
Dr. Church, I agree. I mean, I think, yes, time has elapsed, but at the time that he needed to have that evaluation done, it was an approved evaluator by the board. And so to me, I would question whether it would be fair at this point to reject, his application as a result of this, given the timing.
I would agree with that. Anyone else?
Yeah, I agree as well, and I think the 3 years is kind of irrelevant, given that he met the 150-hour
That's
requirement.
a good point, too.
So
Okay.
I don't have a problem.
Okay. And I think it was appropriate for NASBA to flag this, given that we have said that this service is no longer approved. So let's do the vote. Karen, would you do the roll call?
Pam Church,
Aye.
Sam Bennett,
Aye.
Brad Buchanan,
Aye.
Brad Floyd,
Aye.
Kevin Monroe.
Aye.
And that's it, right? I've covered all of them. Thank you.
Thank you, Dr. Church, and we will talk more about this tomorrow, but I think today and tomorrow are your last meetings
They
with the board.
are.
And thank you so much for leading the licensing committee and also this year serving a dual role as secretary of the board. And
Thank you.
so we very much appreciate your
Thank
leadership.
you. Happy to do it.
Thank you.
It's been a pleasure.
At this time, I'll turn the meeting over to Chairman Griesbeck of the Laws and Rules Committee.
Thank you, Mr. Chairman. At our last meeting, our committee reviewed the discipline matrix as approved by the board in October of '23. This sets out guidelines for civil penalties as prescribed in our law and rules. And after some discussion, we asked Mr. Lott and also Ms. Binkley to explore how penalties for peer review violations are computed, the basis on which, and the amounts. And then we also asked them to consider, do we need to make any other revisions in their minds to our discipline matrix? It's good to review them periodically. Like I said, the last one was about a year and a half ago. And finally, we discussed possible imposition of investigative cost and other administrative cost to violations that are handed down or where we have our penalties. Can we potentially add some of our investigative cost to those? And there was some discussion at that time, but I would open it up to the two of them to maybe let us know what they were able to determine or how they may advise the board at this point.
Yes, sir. On that first question about the peer review, this also will touch on the second question, just the matrix as a whole. I think the matrix gives a lot of leeway to the board. It explains the authority. The matrix is very clear to show that it's only a guideline and that there's no limit in the guideline on the board. The board is free to explore whatever penalties are appropriate for the wrongdoing. Specifically on peer review, there's a contemplation that it can be imposed on multiple, if it is a failure over multiple years, it can possibly be done on a per year basis. The law on that, as I discussed last time, does impose on the board the duty to find facts to support any penalty for peer review. To get a full appreciation of the board's authority here, though, I think it's important to look past the matrix. The board is guided and led by the statutes and then has our promulgated rules. And the statutes lay out, I counted up to 15 different types of discipline. So it's not just a question of civil penalties. It's not just a question of suspension or revocation. And if you don't mind, I'll quickly, in a breezy fashion, kind of read through it just to give you an appreciation and a concept of what I'm talking about. There's, of course, letters of instructions and letters of warning. The letters of warning aren't specifically contemplated by the statutes, but the statutes do speak of reprimand and censure. CPE requirements can be imposed. Probation can be imposed. Of course, here we're talking about probably a non-licensee, or at least someone who, if someone isn't doing their peer review, isn't enrolled in peer review, we don't know whether they're licensed or not. That could be an extra issue. Of course, there's the civil penalty that's specifically contemplated, mentioned in our Accountancy Act, and then spelled out by dollar amount in Statute 56-1-308, $1,000. That's per violation. So if there are multiple violations, like the per year thing on the peer review, you can have multiple civil penalties. Of course, that's a per day thing. That doesn't necessarily apply in the enrollment of peer review context, but that is part of your arsenal. The board can impose costs. The board can refuse to renew a licensee. This doesn't spell out refuse to allow peer review or anything like that, but that is an interesting form of discipline, refusal to renew, that we don't see a lot. Of course, suspension and revocation are specifically mentioned. There's the ability to limit the scope of practice, expressly limited by order. Limit the scope of practice of a professional, of a licensee. Also, for more egregious violations, kind of knowing violations, the statutes, the Accountancy Act itself gives the authority to the board to bring information to the attention of the Attorney General or of any other appropriate law enforcement officer for consideration of criminal action. The violations that are spelled out in the Accountancy Act are misdemeanors. 62-1-114 clarifies that. And then in 62-1-112, there's provision for seeking an injunction from a chancery court. And of course, a violation of an injunction could result in additional sanctions for the licensee or for the individual, such as contempt of court. So I count about 15 different things that the board can do. So I think it depends on the case. This is not a cookie cutter exercise. The board I know, addresses each case on its own facts. Each case is unique. Each case has its own nuances and its own important features, and comes up with the appropriate penalty for each one. So in each case, you can look at all 15 forms of discipline. So that's to answer your first question on peer review, and it really, I think, goes into your second question on the matrix. But do you want me to answer any questions you have about the peer review question before I go to talk any further about the matrix?
I don't have any. Does anyone else have a question related to peer review? Or a imposition of penalties for that?
I'll touch on this, and this is kind of blending with question number 3. For peer review, we can also, with a consent order, if the board decides to impose discipline against someone based on a peer review violation, costs, as I mentioned, are part of the arsenal, right? That's something you can impose. There are 2 phases, really, to any case. There's kind of the initial settlement. Once you decide to impose discipline, we approach the licensee or the respondent to discuss settlement, and they can enter settlement with the board in a consent order signed by both the board and the respondent. And we can include costs in that, and I think the board specifically asked about that last time. The one thing, and Mr. Johnson might want to add to this, he's the one who pointed this out. He's had a lot more experience dealing with these cases. When you try to front load a lot of costs, and front load is not the right word, when you try to include costs in a consent order, you do run the risk of kind of disincentivizing a respondent to settle. And you essentially forces our hand to then go forward with a contested case. And then at the contested case level, that second level where you're actually going before a tribunal, of course, here in these particular cases, in these accountancy cases, the board serves essentially as a jury. An administrative law judge is there to preside over the proceeding. Costs of prosecution, investigation, and the hearing itself can be imposed by the board. So costs are possible at the settlement stage, and they're clearly allowed at the hearing stage. So it's kind of hard, at the settlement stage, it's harder to get a substantial recovery on costs. And of course, the costs are less. It's earlier in the proceedings. On your second question on the matrix, Ms. Binkley and I reviewed the matrix. We went over it in detail. We find that it continues to be a robust document. It's very helpful. It's very well drawn out, very well drafted, very well considered, many nuances, consideration of mitigating factors, consideration of aggravating factors, recognition of the legal authority and the legal limits, a clear express listing of the statutory ranges that are allowed and permissible. So it's lawful. It lays out what the board may do. It's also strong in that it clearly shows its guidelines only, okay? It's not the law. It is important for consistency and for consideration, but it's not the law, it's a guideline. And the board has full authority to go beyond the matrix. If there's a way to tweak it, sure, there are a couple of things. I think the title probably doesn't fully appreciate the contents of the document. I think the title says civil penalty matrix. In reality, when you look at the document, it includes not just civil penalties. Mr. Griesbeck, you asked me a question whether a civil penalty is merely a dollar amount, some kind of dollar finding, or does that include other forms of discipline? I've looked at the statutes. 56-1-308 specifically defines, it doesn't have a definition section, but it speaks of civil penalties and dollar amounts only. So a civil penalty is a dollar amount. It is a finding of some amount owed by this board. Okay, so the title of the matrix says civil penalties. Well, really, it's more than that, because it also talks about letters of warning, suspension, revocation. So that's, maybe we could tweak that. Another thing that possibly we could tweak, I think there are probably a couple of, if we are going to leave the phrases suspension and revocation in there, there might be a few extra lines where the board wants to include that, so it's specifically contemplated in some of the more egregious wrongs. Then Now, another alternative, of course, would be to just take out from the text of the matrix itself any mention of discipline forms other than dollar amounts. You could just take out the phrases suspension, revocation, and letters of warning, and that would then make the thing fit real, in a nitpicky way, fit the title civil penalty matrix. But as I say, it's a robust document, and it triggers thoughts. It is a good thought-provoking document, and when you see a particular violation, you're asked to go through and consider a full range, including suspension or revocation for those worst violations. So I think that's up to the board how they might want to tweak that. I probably would suggest maybe just changing the title, just to make it broader, to reflect what it really encompasses. And then, of course, if you do that, you can include all 15 forms of discipline. And it's not, when I say 15, that's just my quick count. I suspect that you could go through and find even more than the 15 I found. But the bottom line is that the board has broad discretion to impose a wide range of discipline forms in the appropriate cases and make sure that that it fits. Each one fits, and we're not treating it like a cookie cutter. So I hope that answers your three questions. I guess the costs, I kind of touched on that already, but I guess the one last thing I could say about costs, Mr. Speed is very helpful on this and has said that, if the board wants us to, Mr. Speed, in conducting the investigations in each case, can simply, as he I think already does, keep track of his hours and add that to the investigative report so that we can have something to point to. If the respondent says, wait, what do you mean costs? We can show them the board and its staff have had to work pretty hard because of your wrongdoing. So some costs should be considered in a consent order. So I think that might be a way to kind of help include some of the costs that need to be recovered in the appropriate case.
Before any questions, Jen, did you have any comments to add?
I think I'll echo what Mr. Lott said in that the more that I studied the discipline matrix since the last meeting, it stood out to me, and I started tinkering with making edits, specifically where we refer to suspension or revocation in that matrix. It stood out to me that it seems like the matrix is more geared towards providing a range of truly what I would consider to be monetary civil penalties. And then there are some instances where some of the violations do have, depending on the number of aggravating factors or the nature of aggravating factors, they do have suspension or revocation listed. And so when we have talked about it internally, that's what stood out to me, is that is the goal of this document to purely look at true monetary civil penalties and ensure that we're applying dollars trying to apply dollars consistently? Or is the purpose of this document to look at the full range of discipline that's available? Because to Mr. Lott's point, I think that the board is not limited by what's in this document, and I know that you know that. The board is not limited to what's in this document when you're assessing discipline for violations.
Just speaking for myself, it feels to me that sort of in response to your point there, it feels like that we've used this, and I like the word consistency. I think it's very important for the staff and for us as a board to obviously apply these things consistently as needed, but not be limited necessarily. But while it does include suspension and revocation, it seems to have a sort of natural progression, an incremental progression across from, mitigating to sort of a normal, if you will, to aggravating. So I think it's helpful to have that, and I would be curious at what any of the others think about that. And then, I would not want this to, if it doesn't mention suspension or revocation on an item, but we felt like it was egregious enough to warrant that, it would seem a little awkward if we impose that and that's not on our guideline is the most severe. Yeah, it's just $1,000, but it doesn't say suspension or revocation for that particular violation, but many others do. And so I don't know if by either adding that to that, we don't get somebody come back and later say, well, how can you do that? This is your guideline, it only says a monetary amount. Or to your point, I don't know if I'm as comfortable, it would be, again, love to hear everybody else's comments, about just putting dollar amounts and not the other. I just think it's nice to have it in front of you to kind of weigh what the remedies are here and normally have been in the past for specific violations. So I'm not sure about removing those and then just adding a narrative, well, we can suspend, we can revoke, we can do whatever, you know.
Right, I think you make a good point. I wouldn't want to take it away and give any kind of impression to the public that in an egregious case, the board would shy away from suspension or revocation. The public needs to be aware that the full range of disciplines is available. And that goes to, it's like making the message clear to the public. So I lean more towards kind of maybe changing the title, maybe adding a few more asterisks that say, oh, other things may be considered, that type of stuff, rather than taking away the guts of the matrix, because I think they've served the board well so far.
Any other thoughts?
I have a question, please, clarification, I guess. I need a clarification. I look at the column that has penalty range and then normal per violation. Okay, contrast that or compare it to, if you will, what was this limitation in the statute itself? You gave a dollar amount from the statute. Are these from the statute or?
Yes, sir.
Okay, all right.
Well, in a way, this matrix consists of, has in statutory basis, the statute 56-1-308, as well as I think 62-1-111 and 113, and probably other statutes.
But there's an actual dollar amount that you mentioned
Yes,
that's
sir.
mentioned in the statute. What is that again?
$1,000, and that's in 56-1-308, which is the chapter that governs all regulatory boards, not just accountancy. It basically says regulatory boards in work in these cases may assess a civil penalty up to $1,000 per violation per day. And some boards, some programs and boards have their own statutory authority for a larger civil penalty. I think protective services is an example. There are several examples. Alarm systems, they can impose per violation a higher dollar amount. That's just because the General Assembly has chosen to, for that specific program, give a higher dollar amount. Thus far, the General Assembly has not given a higher dollar amount to the Accountancy Board. I suppose the General Assembly could do that. They could issue, that's up to the legislature.
Thank you. And where does the dollar amount from the aggravating factor column come? Is that the $1,000 or is that just
The range is
discretionary?
provided by 56-1-308. It's, I forgot how it's worded, but up to 1,000. And then the numbers that are put in the matrix, I think were for the aggravating and mitigating columns. Those dollar amounts are basically, or kind of, as I say, a guideline that was established primarily for the goal of consistency and making the message clear to the public what's possible, and also to give the staff guidance in trying to evaluate each case.
Okay.
So-
Well, I note that the aggravating column does not exceed 1,000. I guess
Yes, sir.
there's a reason for that, right? I guess
Yes,
it's
sir.
the statute.
Exactly.
Okay, all right, thank you.
Hope I
Thank
answered
you.
your question.
I think the rule actually says 0 to 1,000, and so 1,000 is our high number.
Okay, all right. I just wondered, I wanted to tie it back to the statute to make sure I understood that. Thank you.
Kevin?
Mr. Chairman, just from a little historical perspective, when this was established, Gabe Roberts was on the board as our as our attorney member, I believe. And he, and at that time, the director, Wendy Garvin, put together the precursor of this matrix. And the struggle that the board was going through was that of consistency. And so, there might be one meeting where we would apply a $500 penalty for a failure to have a firm permit, and another meeting where we'd apply $1,000 under seemingly similar circumstances. And so the idea was to try to get some consistency around that. And it was not designed to preclude suspension or revocation. It was really designed to get some consistency there. And I think that we last reviewed this as a board back in 2023 or thereabouts. And it was in essence, a board reviewed, if not approved, document. And it is only that, a guideline. And we're going to give the guidelines a pretty good workout this afternoon in the Enforcement Committee report, because we're going to have a case or two that we may well need to go beyond and into the territory that the council was talking about with respect to referral to a state attorney general or a DA on one particular case. So we'll have a good chance to kind of talk through that.
And I think, I like the idea of maybe going through one more time for some tweaking. And, we talked about peer review at the last meeting and the possibility that maybe our penalties were not necessarily a deterrent for people not subjecting to peer review. And I think, some language revisions could potentially give us additional arrows in the quiver, used arsenal, when we have a situation that we feel like is egregious. So I think I like the idea of that. Any other thoughts on the matrix in particular?
Mr. Chairman, I'm not on the committee, but may I ask a question?
Absolutely.
Mr. Lotz, and Lee, this may be encompassed in what you've already discussed, but if I look at the first page of the discipline matrix, which is the narrative, I would say, the first item in bold, aggravating factors may increase sanctions. If we added parenthetically there, including possible probation, suspension, and revocation, close parentheses, is that a possibility to make it clear that those are options?
I think so. I think anything that speaks to the fact that we can go beyond this, as you sort of began your conversation, as far as limits.
Yes, sir. I think that would be a good place to add it, and probably could find a few others. And for the more problematic areas that the board encounters, like peer review, maybe add some specific language on that line. So I agree.
But I think to your point, Kevin, it is a robust document. I'm glad to get that historical perspective. And, this isn't the first time we've sort of struggled. This struggle is a lot easier than the previous one, the original struggle.
I think it largely is. I
Yeah.
mean, we were spending, hours,
Yeah.
on the goal, chasing after consistency and trying to remember what we did at the last meeting. And Mr. Roberts just did a phenomenal job, along with Wendy, of sitting down and putting something to paper that was then vetted with the board at that time. And it was acknowledged from the get-go that these are guidelines. What governs our ability are statutory provisions. And so, licensees are bound by those provisions, and our guidelines are designed to provide guidance, but we have the flexibility within the statute to mete out whatever discipline we think is appropriate, as long as it's sanctioned within the statutes.
Right. We're really using these to apply the statute and the rules related to these violations.
Might I add, just ask or add one final thing? This is per violation per day, right?
That's right.
Okay, so I guess the question would be, what does per day mean? Can a peer review be violating 30 days? I mean, is that one violation, is this continuing on? Or I guess if we nail that language down a little bit, we have a little more flexibility there.
Well, we had some discussion about that in February, as I recall,
Yes,
Mr.
sir.
Lott, and you kind of brought us up to date, and there's even some cases out there that maybe help delineate that. part
That's
of it.
exactly right. You're right. The law is very clear. Each day of continued misconduct is a separate violation. And So if there's evidence to show activity, violation, activity occurring on multiple days, then each one can have a $1,000 civil penalty. But the challenge there, of course, is to make sure that the evidence is there. And Mr. Speed, I think, is very good about going through and gathering all the information that's available. Of course, it partly depends on the cooperation of the complainant and the other parties, to the witnesses and the respondent. But once we get the evidence in, we can explore it, and in the more egregious cases, go through with a fine-tooth comb and say, look at here, look, you have a billing sheet that lists 17 different days, and maybe somehow a larger number would fit that particular case. Oh, Mr. Johnson, yeah.
Just wanted to add to that, if there is a possibility that we can issue that per day violation and tack additional $1,000 on that, we will let you know in the report. We're doing our best to gather that evidence. If you don't see it in the legal summary, it means we don't have the evidence to do that per day violation, but we're continuing trying to gather, whether it's timesheets or if it's multiple attest reports that they've issued, and we've gathered throughout the investigation. We will certainly let you know if you're able to tack on more $1,000 penalties.
Great, thank you. The only other thing I would ask is maybe, Mr. Lott, if you could speak to the cost, and I think either you or Jen, one of you at the last meeting, talked about maybe the status of other departments, how they approach imposition of any administrative, legal, investigative type cost. One, is it ever done? Two, if it's done, is it more at the hearing stage versus the investigative and an order?
I can address that.
Maybe sort of some of the practical issues
Sure.
we're dealing with.
I would first say that I think we need to keep in mind is that on these cases, when we're making our recommendation, we're getting you to authorize formal charges, which would be down the road. And then after that, as you see in the recommendation, you're authorizing a settlement. So I think the amounts that we're putting in these reports, you need to keep in mind that that is the settlement offer that we are making them. So that's in the middle of the stage. You've got all this opportunity to assess these investigative costs, attorney fees, if it reaches the hearing stage where we have to file those formal charges. To touch on the first topic, it is not common for any boards to, in their settlement offer, state that we're going to assess these investigative costs or attorney fees. I think you got to think about strategy, and the settlement offer needs to be generally fair. And really, in all aspects of the legal world, it's not common to ask for attorney's fees or other costs in a settlement. I think it could actually deter people from settlement, and then you run the risk of, that's fine if they don't agree to it. Well, we're going to file the notice of hearing and charges, and we can seek all those down the road, but you still run the risk of, we're not recouping a penalty in that like we are immediately during a settlement. So at that point, we've recouped no money. We've got to go to a hearing, and then if we get a judgment against them, they still may not pay it. So I think you gotta weigh those risks and just keep in mind that these are just a settlement offer, and you've got all that authority with the cost if it gets to the hearing stage.
So it's probably safe to say we had this available to us, but routinely, we're not going to do it, just as we never have, to my knowledge, in the past. And it would probably take a special set of egregious, I'll use that word, circumstances to maybe feel like we needed to do that, or maybe extensive cost also.
I think you could still consider it in individual cases if there's an aggravating factor. Right. You may want to offer that as a part of the settlement. Well, this is a little aggravating, so we're going to tack on the investigative costs here. So just you can depart from the matrix and say, you maybe want to consider tacking on costs in this settlement. But as far as generally, it's not common, and I think it may deter, and I think it's better to go ahead and if they want to agree to the settlement, they're on the disciplinary action report. We've recouped that penalty. If it's aggravating, they don't agree, then we've got all that stuff that we've still got in our tool belt that we can go to the hearing. If you lay that all out during settlement, you're kind of just throwing all your cards out, and that's pretty much all we've got at this point. So I think we need to keep some stuff in the back pocket for the hearing.
Any other questions for our team here related to these issues? So I think we we kind of know where we are on the cost imposition at this point. I think it's much clearer. And then as far as the peer review, what we talked about, some of those, I think we have those options available to us if there's something to go beyond what we see on the matrix, if it calls for that. I think it would be worth a little effort to just tweak this at this point, now that it's fresh on our minds. I don't think it's going to be a lot. And, maybe it's the title, maybe it's some of the things that Mr. Gilbert pointed out. Maybe it's either adding suspension revocation on a few other items where we think that might be necessary, where it's not mentioned now, or if you feel like with asterisk and whatever, maybe that could be denoted as another potential penalty, so to speak. Anything else from the committee? Okay, can I leave it at that? I don't think we have an action as such, sort of like we did last time. And just
I
ask you to
agree.
come back to us.
Yes, sir, I think that's right.
Thank you.
Thank you, Mr. Griesbach, and Lee and Kyle. Thank both of you for your input on this and help with it. And of course, Jen as well for reviewing the matrix. And also for Kevin for, you did extensive work. You minimized your role in it a couple of years ago, but in reviewing the discipline matrix, I know you spent a good bit of time with Wendy on that too. So thank you for that work, Kevin. At this time, I will turn the meeting over to Chairman of the Enforcement Committee, Kevin Monroe, and as was the case with Dr. Church, today and tomorrow will be Kevin's last meetings with us, and I believe that's correct. And we very much appreciate your leadership, Kevin, and you have done monumental work. My mind always goes to the Enforcement Committee because I'm so amazed by the way you succinctly summarize the cases but get all the relevant facts in. I could never do it that well, and so thank you for your work. But anyway, I'll turn the meeting over to you at this point.
Thank you, Mr. Chairman, and don't jinx me here.
Mr. Monroe?
I feel like, I'm about to sink a putt, and the commentators are saying, well, he hasn't bogeyed it yet. So I'll do my best here. And so the first item is the case and complaint report. This is an information-only report. These items, none of these items are included in the items we'll discuss and act upon in the legal report subsequently. This is just a summary of the open complaints. Nearly all of those that are open for any length of time are relating to the fact that they're in litigation monitoring and really beyond our control or the control of the director or staff in terms of bringing them to closure. We're just waiting for the legal development. So I think the departmental goal here is trying to get things closed within 180 days, or at least getting 90% of things done within 180 days. And particularly when you take out the litigation monitoring elements, we're well within that. And then we have to deal with the litigation monitoring in the overall metrics. But this is just an informational report summarizing that. Some of these, particularly those where we've received things, let's say in April, may appear at next quarter's legal report, but they'll have to be worked through and the investigation will have to be done. The next item is the legal report. And in this particular case, what I noticed when I was doing my pre-review and then working through questions and comments with counsel and with the executive director, in this particular quarter, even some of the consent cases have interesting fact patterns. And so we'll summarize those and go through those. And then the other thing I would just note up front that in the proposed discipline cases, cases 12 through 20, every one of them but the last case relates to a referral or a complaint opened up as a result of a referral from the contractors board or the licensing board. They're giving us some good business, but we're continuing to need to work to find a way to try to head this off at the pass and use their work, which is a detective control after the fact, and try to see if we can move toward a preventive control before the fact to head off CPAs getting into trouble and banging their head against the wall after the fact, saying, oh, I messed up and I've got a penalty. And so we'll go through those cases as well. And I will say that the disciplinary matrix came in handy because when I was reviewing things with counsel, it's like, okay, I see this is the aggravating factor and so forth, and we really did try to be consistent, but, input is welcome on those. So we'll start going through the cases here. So cases numbers 1 through 11 in the report are consent items, meaning that there's no civil penalty or discipline imposed. It may be a recommendation to close, or it may be to issue a letter of warning or a letter of instruction. The first case in the consent agenda is one that basically is a complaint that is unrelated to the matters on which our board has jurisdiction. So the recommendation is to close. The second case also is a jurisdictional case. The owner is not a licensed CPA and the board lacks jurisdiction, so the recommendation is to close. The third case is essentially an employment dispute, which is also not really within the board's jurisdiction, so the recommendation is to close. The fourth case, has a set of allegations by the complainant against the respondent, but there was really, upon investigation, not enough evidence to support or to establish a violation that could then be adjudicated. And so the recommendation is to close in this particular case. Case number 5 is one that I would really like to have some discussion on the part of the committee and all the board members that would like to weigh in. This is also a Board of Licensing Contractors case regarding a review report that was issued, and basically the issuer was an out-of-state CPA. And in the state that the issuer is from, peer reviews are not required to issue a review report. However, the review report was issued for an entity in Tennessee. And so we had a lot of discussion in my pre-review with council here as to, well, what do we do? So for discussion purposes, the recommendation that's presented here is to close with a letter of warning, not to impose a civil penalty. And the distinguishing factor between that and the cases that we're going to deal with in the proposed discipline section are that this was an out-of-state CPA who, from their perspective, did not need to require a peer review to do what they did in their home state, but they do need a peer review, and it's, the contention here is that this is a violation of Tennessee rules. And so, essentially, that's the conundrum. Do we treat this and leave this as a consent item, meaning letter of warning or letter of instruction or close, or do we move it to the proposed discipline item and impose the type of discipline that we typically would on an in-state CPA who did the same thing? And so I guess at this point, I would just welcome input and discussion from any of the committee members or other board members who are not on the committee, because we'll all be grappling with this one tomorrow.
Mr. Chairman, I read that, and I went through it, and, the person obviously is acting under mobility, and under mobility, you're supposed to understand the rules and laws within that state, and I'd question, hey, we're not doing anything here? I mean, it seems like to me that we should be fining this person because they did not reach out and understand the rules and the laws here before they did something. And that may be more prevalent in the future, too, the way mobility is coming across.
Other comments or questions on this one?
Mr. Monroe, one question I had was just whether or not there was an actual issue identified with the quality of the review.
That's a good question, and for that, I'll turn over to the investigator and legal counsel.
Unless our investigator has any additional information, I don't think there was any issues with the quality of the review.
I think really they were simply unaware that Tennessee had that requirement. And, that was the crux of the matter.
I would just add from this is my case that I handled. I guess the mitigating factor for me was that obviously this was a violation. They should have complied with Tennessee rules here, but I think it was a misunderstanding of which law was applicable. Since their firm was located in this out-of-state, they thought they only, for some reason, had to comply with the out-of-state requirements, which were a little less than ours. And they were just simply unaware that and there was a little disagreement about whether they were actually practicing here, but it was a Tennessee-based company. So from our standpoint, this is a clear violation. But it did seem like there was no ill intent behind it. It was a misunderstanding of they thought their laws were applicable when performing this service, but it was clearly our rules that were applicable. So I think you can go either way. I certainly haven't been a part of a case yet where I felt like I haven't seen a letter of warning and what yet with this board and when y'all might lean that way. So if you want to go another way, I think it's certainly appropriate, and I can get behind that for sure.
I have a question.
Do we have,
I'm sorry. Did someone else?
sorry, that's me over the phone.
Oh,
Do
go ahead,
we
Brad.
happen to know the opinion? I presume it was if it was a review report, a review opinion would have been issued. Do we know under which or what the location was on the review report? Was it an actual out-of-state office, or was it somehow a Tennessee-based report in that regard?
I think the firm is out of state, so the presumption is the client was a Tennessee-based company. So I think the presumption is it was delivered via email, or I assume that's probably, I'm not sure what the standard practice is there, but it had to have been sent electronically if it made its way to the Tennessee Board of Licensing Contractors. But I think the work was all done. The work was all done in the out-of-state office.
My question is, I haven't prepared one of these license applications in years. Is this one where the CPA firm fills out the forms online with this licensing contractor board, or do they just, here's our review report, you attach it as an attachment to your application client? How does that work?
It's the latter. The licensed accountant is not involved with the board. It's usually they issue the report to their client, which is presumably the contracting company applying for their license. And then from there, they take it over and they submit that.
Were they even aware that this was going to be used for application then? That's kind of my point. We issue a review report, client takes it and attaches it as an attachment in a form that they have filled out, and maybe the accounting firm was unaware of it.
I'm not sure I can answer that question. I can say in other cases, there's been a lot of times where the licensed CPA or whoever it may be was unaware that it was being provided to the Board of Licensing Contractors. But I think certainly they were aware that their client was a Tennessee-based company in this circumstance.
Yeah, they were referred to by a consortium, like a working group of general contractors, and was referred to our respondent. So the respondent knew what was going on and why the review report was necessary.
So did they rely on the report and issue the license? I mean, it seems to me that they would reject the submission and not issue the license, and that would be how it would be disposed of, rather than coming to us and asking whether or not we should.
Well, I think the contractors board, yeah, they would reject the report, but because they believe there may have been a license or a violation under your purview, they refer it to you as well.
Got it. So they basically probably had to go back and get a different review report.
Yes, in most cases, that's what happens with these, is they'll go back and get another appropriately licensed CPA to do it.
Got it.
Mr. Floyd, any other comments from the committee membership here? I'll agree. My first reaction was the same as Mr. Bonner's. It's like, well, do we really want to send a signal that it's okay to do this, for an out-of-state CPA that is supposed to be following Tennessee rules? And so my threshold question was, are we sure that this is a violation in Tennessee? And I think the answer has been from council, yes, it is. And I'm hard pressed to take a view that we should, for the same violation that we would punish a resident Tennessee CPA, why would we not be consistent in punishing an out-of-state CPA with respect to that. That's kind of what my dilemma has been.
And I agree with you. I think that we have to hold it that way, because if people are going to come into our state, and just like our driving, if our driving laws are different, and you take that right on red, when your state allows it, you're going to get that ticket. And so it's the same principle. If you come into this state with a license and you don't understand the rules, then you can have an issue too, and in this situation, they did.
Would like to open it up to any other board member comments or leanings one way or the other on this, because we're all going to have to grapple with it tomorrow.
Mr. Chairman, I just have one comment, and that is, it seems to me that the Tennessee CPA is at a disadvantage in this situation if he or she has to comply with peer review, but yet an out-of-state individual who's practicing in Tennessee does not have to comply with the same rules. So I would agree with both your comments and Mr. Bonner's.
Yeah, I guess where I would come down on this, if because of the misunderstanding, the client was not able to use the review report, and the CPA firm, as a result, either reduced the fee or returned some of the fee, then I would be more sympathetic, I think. If the CPA firm kept the fee for performing an act that they weren't licensed to perform, to me, it seems like a penalty would be appropriate, because why should they keep the fee for work that they did that they weren't licensed to perform?
But when we have a Tennessee CPA come to us and say that I issued a report, I didn't have a peer review, I'll just give the fee back, we still penalize them for not knowing the law.
Yeah, so the question would just be whether we hold out-of-state CPAs to the same, to the same requirement of knowing our laws, right? That's what it ultimately comes down to. Given that there are some complexities in understanding different state requirements.
Just one clarification, Duke. You did say they were aware that this review was going to be used for this purpose. That's why they issued the review report.
From my understanding, yes, because they were contacted by the client because it was needed for a contractor's license.
Okay, well, in that case, I mean, I'm sort of with Mr. Bonner on that then, now that I think of it in that manner. So they did not know the law, didn't know the right turn. That's an excellent example, actually. Right turn on red, and your state does and we don't, or vice versa.
So if we go the penalty route, what are our violations? Peer review?
It would be peer review because there's no evidence of a firm permitting issue. I mean, they were practicing under mobility. They had the right to do that. So the fact that they didn't need a Tennessee firm permit to practice here. So it would be basically the failure to get a peer review, and it would probably be the standard penalty, or maybe you could, argue mitigation based on out of state and shave $250 off it or what have you. But I think that's what it would be.
I would just add that the firm did have an out-of-state firm permit, so they were in
Okay.
compliance with all those rules. The only one we're here considering, the violation is a peer review violation, lack of enrollment in peer review. For that, you have authority, like we've discussed earlier, from $0 to $1,000, and then the matrix provides you with some of those consistent, mitigating, normal. And actually, I think with peer review, and I think we've discussed this, but I think with standard, just 1,000 on the peer review across the board is what we generally do for that, according to the matrix.
I think I would agree with the comments so far, but I would probably also suggest the penalty be mitigated.
What I would offer up for the committee's consideration on this one is that we go ahead and we'll move it into the proposed discipline case tomorrow for the board's activities, but that we would have the standard language surrounding the peer review violation and propose to settle with a $750 civil penalty. Is there comfort on that? All right. So what we'll do is, why don't we normally we would vote on all the consent cases at one time, but why don't we take this one out since we're going to end up moving this to a proposed discipline bucket tomorrow for board action, and just deal with this case now in terms of the committee vote. And so rather than close with a letter of warning, we would effectively have a recommendation. Let's see if I can find a good example here, where we would request authority to commence formal proceedings against respondent and authority to settle the case via a consent order with a civil penalty of $750 based on violation of our peer review rules. I'll make that in the form of a motion. Is there a second?
I'll second it.
Any further discussion? If not, I think all of the committee members are present in the room, so just a voice vote. All those in favor say aye. Aye. All those opposed say nay. All right. That motion passes, and so what I would ask council to do is to just move this to the proposed discipline section. If you want to move it to the end so it doesn't mess up the numbering on all the others, that's fine. And
Yes,
then
sir.
we'll deal with that in that
We'll
bucket
get it
tomorrow.
moved to proposed discipline with y'all's committee recommendation listed on there.
Okay. All right, let me get my notes back here. The next case in the consent item is item number 6, ending in the digits 1341. This is a case that where there is a legal dispute, and so the recommendation is to move this to litigation monitoring. The next case, item 7, is a case that is recommended for closure based on the fact that based on the investigation that was performed, there was insufficient evidence to establish a violation of the Tennessee Accountancy Act. Item number 8 also is another litigation monitoring type of case with no action recommended. This is also being addressed by Mississippi regulatory authorities, and so the respondent is a resident of Mississippi and does not have a license in Tennessee or Mississippi, and so the first line of pursuit there will be from our colleagues in Mississippi. Item number 9 is a case where we have a letter of warning being issued. This is related to a very late in the tax filing season cancellation of an engagement by the respondent. That's not in dispute. There were some issues around that. The respondent did endeavor to provide the client with another CPA, and as it ended, basically extensions were able to be filed and no great harm was brought. And so the view here is to recommend a letter of warning under the due care provisions of the statute. Item number 10 is another case where there is insufficient evidence to show a violation, and so the recommendation is for closure. This is following an investigation on the part of Mr. Speed to try to obtain documents that could support the complaint, but they were not provided any such documents. Item number 11 is again also another case to close based on insufficient evidence to support a violation. This relates to a potentially incorrectly filed 2022 return, but there was no evidence really containing statements of fact that would allow a case to proceed, so the recommendation is for closure. So let's go ahead and deal with the consent item cases as a committee first, remembering that we've excluded the case, I believe that was item number 5, with respect to that, which is being moved into proposed discipline. So I would accept a motion to accept the recommended discipline in the other consent item cases 1 through 4 and 6 through 11.
I'll second it.
We have a motion and a second. Is there any further discussion? All those in favor signify by saying aye.
Aye.
Aye. Any opposed, say nay. All right. Now we're going to begin with the proposed discipline cases, and these are cases where a civil penalty or other penalty is being sought. As I mentioned at the outset, these reflect items numbers 12 through 20 and items 12 through 19 are all essentially referrals from the Board for Licensing Contractors based on either review or compilation engagements that have been issued without either a firm permit or peer review or some combination thereof. There is one case, number 13, which we will talk about. I mentioned earlier that we may want to pursue things beyond the civil penalty, given the repeat violations and what was uncovered during the investigation. So we'll deal with that one in and of itself. So item 12 is a case where basically 2 review reports were issued. The issuing entity did not have a Tennessee license, and the firm named in one of the review reports was not permitted or enrolled in peer review. The individual, this involves both an individual and a firm. The discipline is being proposed against essentially the firm. We also had a California CPA that was involved, and this one kind of warrants some attention. So in essence, we had a referral from the contractor's board. The individual who signed the review reports did not have a Tennessee license, and that the firm named in one of the review reports was not permitted or enrolled in peer review. So the disciplinary case was initially opened against the individual, and it was determined that that person was a licensed CPA in California, and that person did not sign the reports. So we closed the case against that individual and opened the present case here against the firm. So then that was investigated, and the respondent had changed ownership. Both contractors retained the respondent to prepare the review reports and were surprised when their review reports were rejected by the contractor's board. The investigation notes that it was undisputed that the review reports were not signed by a Tennessee licensed CPA. The respondent lacks a firm permit, and the respondent is not enrolled in a peer review. And so essentially you had 3 violations racked up for each of the 2 review reports that were issued. And so the proposal for discipline is to request authority to commence formal proceedings against the respondent and authority to settle a case via consent order with a civil penalty of $6,000, consisting of $1,000 per violation, as listed for each of the 2 issued review reports. And so that is the proposal here for this case. Any questions or comments on this one? If not, I'll proceed to case number 13. This one, we have some history. The complaint, one complaint was issued, and a consent order with $5,000 civil penalty for unlicensed activity occurred as recently in 2024. Following that, the Board of Licensing Contractors received a review report signed by the respondent and asked us, as they normally do, to assist after the fact in license verification. The respondent signed the review report with the designation CPA, but the license expired for non-renewal back in 2013. The respondent does not hold a firm permit, and he is not enrolled in peer review. He was previously the subject of a case for substantially identical conduct. In that case, the respondent did execute a consent order and agree to pay a civil penalty in the amount of $5,000, but to date, he has not paid that civil penalty. In the present instance, the new complaint, if you will, the investigator attempted to reach the respondent, who was unresponsive. They interviewed the contractor who hired the respondent, and of note, as you see in the language in the actual report, and I want to read this because this to me is one of the reasons why we may need to go beyond our normal scope of discipline here, where essentially the respondent replied to the contractor's spouse saying, "We're working on it, we'll get back with you today. I've got a guy that works for me that is at that level, so he's trying to see if he can squeeze it in. That way it doesn't cost you anything else. The peer review requirement for all levels is new." And then the respondent ceased to respond to any further attempts of contact with the contractor. And so in this particular case, we have a clear repeat violation by someone who is, not in a properly licensed state. So the recommendation here, tentatively, is to request authority to commence formal proceedings against the respondent and authority to settle the case via consent order with a civil penalty of $5,000, consisting of a $1,000 penalty for each of the above described violations of several rules. And then you'll note the language here, we may wish to consider additional discipline. This is one of those cases that I think we should consider referring to the State Attorney General's office and/or the appropriate local district attorney for follow-up. We can't require them to levy charges, but we can bring it to their attention. And in my view, we have a serial violator that is basically thumbing their nose at the board and is putting the public at risk. And so, his license, I mean, he's effectively unlicensed, so I'm not sure what good it would do to revoke a license because that isn't stopping him. And so I would recommend that a part of this, that we append to this recommendation from council, that we direct council to seek to refer the matter to the appropriate officers in the State Attorney General's office and the appropriate local law enforcement jurisdiction for their consideration in addressing this matter, in addition to the civil penalty that is being proposed here. Comments or discussions on this one?
Has the original 5,000 still not been paid?
Not yet.
Mr. Speed, do you have any further kind of color commentary to add based on your investigation?
Yeah, so in the first investigation, when I talked to our initial contractor, one of the things he made comment to reference was when he confronted the respondent about the rejected report, the respondent responded to him saying something to the effect, yeah, this happens once every 20 times. So there's a concern that there's not just these two reports, that there's a lot of this happening. Also with our two contract victims here, they all run in the same social circles, so there's a concern that there might be more people out there because they kind of seem to be referred by the same group of people. So that's a concern that there's not just these two incidents, there might be more.
What do you think he meant by let's run it off that guy's letterhead?
Well, I have a sneaking suspicion what he meant. Is find someone else to do it and just copy it over and send it through. Again, in the first investigation.
Or just use the guy's letterhead? They said the guy works for him.
In the first investigation, what had happened, there was it appeared to be an attempt to use somebody else's name and license in the first investigation. So that's my concern, is it was just a copy and paste of somebody just to get it through, just to, Yeah, I don't think he was making sure that this was a whole new engagement to make sure this was on the up and up. I think there was probably something else there.
Any other questions or comments? Brad?
I agree with you, Kevin, that the egregious nature and the multiple mitigating factors require that we refer this on to the Attorney General or whomever would prosecute in this case. But is there any way to offer some significant penalty, even though the individual is not licensed and really is not under our jurisdiction at this point? There's nothing much we can do relative to revoking a license that doesn't exist.
I think that's the conundrum. I mean, the civil penalty that we're applying effectively is the max. It's the, it reaches the limit of $1,000 per violation. And he's effectively let his license lapse. And so what good does revoking it do?
May I add one thing there? The statute does say one of your available penalties is to refuse to renew. As I understanding, if someone, and Ms. Condon, please correct me if I'm saying this incorrectly, if a former CPA allows a license to expire, as this one did, then that person to renew has to complete 80 hours of education that's called penalty CPE. That must be done within the 6 months before the request to renew. But the point I'm making is that they can renew. And so the board, if it wants to, could add language that says, additionally, this person is not permitted to renew without coming before the board. And I don't know exactly what conditions you might want to add to that, but essentially you have that authority to refuse to renew for a period up to 5 years. And I'll add this too about revocation. I have heard in other professions that even a license that is expired or surrendered, because it can be renewed by request, can technically be revoked. And I don't know if that's the right wording, but we could explore that and do some research if you want to look further at revocation, because that word carries weight. You know, the action carries weight, and it would be a strong deterrence across the profession and across the bookkeeping and tax services field. I don't know if that's helpful or not.
Thank you, Mr. Lott. One question I would have on the first point with respect to renewal. My understanding was that whether or not we mentioned anything about, having to appear before the board to renew, if this respondent does ever decide to renew his license, we are not automatically bound to assent to that. Is that correct?
I defer to Ms. Condon on that. That's a question I've never answered.
If the respondent wants to get back to active status, he will need to submit an application to reinstate the license along with the CPE. If we were to receive that, we would review the file and see that there are these pending issues. So we would not automatically approve it without doing further review.
Okay, so essentially it would have to come before the board, most likely. If we wanted to, if the staff recommended it would be renewed, I would just put a proviso in here that says it would have to be brought before the board before it could be renewed.
I think that's something that you can definitely put in with the discipline. I don't know, I think what Karen was referring to is if someone with a history of violation applied to reinstate, that would cause my team to pause and consult with legal before moving forward with that reinstatement.
I would just add, is there a way to flag the license? I think that would be what would be appropriate, is you could put in the language in your decision to also flag the license. That way the issue comes before the board again if they decided to renew.
So it appears that we have some options. And so right now what we have agreed to is tentatively to recommend to the board is the settling the case with a consent order with a civil penalty of $5,000 consisting of $1,000 for each of the violations. Also a referral to the State Attorney General's office and the appropriate local law enforcement opportunity officials to pursue this particular case. I think, to me, given that the fact that renewal would not be automatic and that there are some safeguards in place that would prevent it from just flying through without us knowing, I don't know that we need to add a proviso in preemptively to not renew him. I think we would cross that bridge when we come to it with the facts that are present at that point in time, if it's 5, 10 years down the line, or never. So I would just recommend leaving it at the civil penalty recommendation along with the referral to the law enforcement agencies. Are the members of the committee comfortable with that?
Can I offer some clarification that in that reinstatement, what I think you just described, we would not, under normal circumstances, bring it before the board to reinstate. Only if the board ordered us as part of that discipline to bring that reinstatement application before the board, that's the only time in that process that we would normally bring it to the board.
I think then on the basis of that clarification, we would add then to our proposed discipline that any future reinstatement would need to be brought before the board and that the respondent would need to appear in person.
I think that's appropriate.
I agree with that.
Mr. Chairman, I'm not trying to muddy the water on this case, but another option that's available to us, I think in all cases, is the NASBA ethics training program. I don't think we've assessed that type penalty or that type requirement before, but that's another arsenal, item in our arsenal.
I wouldn't object to that either, given this guy's responses. I mean, I'm tempted to remember, there's a quote, a funny story between Henry Kissinger and Richard Nixon during his presidency, where Mr. Kissinger had laid out a list of options for him to basically punish an adversary during the Vietnam War. And Nixon allegedly wrote back, "I like them all." And so I wouldn't object to that either. How do the committee members feel? So we will also add a requirement to successfully take the 3-section NASBA ethics course here with respect to this respondent.
Mr. Monroe, if it's okay, I'll research that a little further to see if I can give any more information that might assist the board. The question I would have is whether CPE could be required of a person who's not a licensee. Of course, it could be one of the conditions of renewal. You have to go before the board, and you will also have to do CPE and whatever else the board wants to do. I just don't know if by itself the CPE can be required of a non-licensee. I just have to look at that further.
I think we would then put it in the context of if he chooses to reinstate
Okay.
or renew. Thanks for that clarification, Mr. Lott.
Yes, sir.
All right, I think we've chased this one around the table pretty well. Any other comments or discussion?
Yeah, Kevin, this is Brad. Just one other question, and this pertains to this case, but all similar cases. When we talk about the harm to the public, part of that, at least in my mind, pertains to the fact that there is a report that's been issued that is not valid. And so the question I have then, is there something that we want to think about in terms of our recommendation? And again, and I say this is weird, at least it's weird to me in some regards, because this person is not a licensed CPA, so therefore the report that was issued is not valid, sort of prima facie, but some sort of recommendation or maybe not recommendation, but some sort of language to say this person needs to inform his or her clients or do something else to make it known that the report is no longer, essentially they rescind the report somehow.
I think that's a good point. In most of these cases, and in this case in particular, because it's a referral from the licensing board, the contractor's licensing board, they have already rejected that report. And so the contractor that procured that report is aware of the rejection and had to then procure a legitimately sourced report. Typically these reports are required only because of the licensing contractors board's requirements, which apply to financial statements of certain, dollar sizes. So in this case, and I think in nearly all of these cases that are, the gatekeeper, unfortunately, it's after the fact and not on the front end, but the gatekeeper is the licensing board, which does the check and then says, nope, we're not accepting this report. You need to go out and do it again to the contractor. So I'm not as concerned that we've got reports, at least for this purpose, flying out, into the world. Does that kind of address concern on your part, Brad?
Well, as it relates to the contracting board, I would agree. But a review report, as we all know, is not issued it's not addressed to the contracting board.
Right.
It would be addressed to management or the board of directors or some body that's affiliated with the reviewee. So whether or not this report is being used for other reasons that I can't now come up with, it doesn't foreclose on the possibility that it isn't being. And so in that regard, that's part of my question. I appreciate that the contractors board has caught wind of this, but there may be others who have not. that, for whom this report, may or may not be relied upon for other things.
I think that's a fair point.
Along those lines, Brad, this is Rob. I guess it's this other mystery letterhead person that works for him. Do we know who that is? Do we have, obviously don't say the name, but do we have a name of that person?
I'm not sure that was a witting person. In the first incident,
Right.
a name was used, but we weren't able to chase down whether that was actually done with that person's knowledge or just done.
Well, I mean, that's kind of my point is that I wonder if it's going to be used anyway, and it was used. Subsequently, when the first report got rejected by this non-CPA, did he then go and just copy it over on the guy's letterhead that works for him, and that report gets submitted?
Yeah, again, I don't know if that person works for him. That's what was represented to the
Right.
client.
Do we have the authority to investigate to see if the report came in under that person's name to the contractors board? I guess also a question I have.
Sure, and that's what we try to chase down. The person that was provided is out of state, so it kind of limited what we could do. The concern was, again, I'm speculating here, I have high doubts that that person worked for him, for the respondent. I think it was an attempt to legitimize the report using deceptive means.
I just hope that report didn't, or that letterhead got used this time. I don't know what we do about that to see if this particular contractor was issued a license and whose review report did they use to get that license?
Yeah, I understand the underlying point of, yeah, you might have been hired to do the review report, but who knows what else has been done with that review report? The board of contractors may have rejected it, but was it presented to a bank? Was it presented to an organization where you might be talking about doing some sort of purchase and mergers? I don't know. So
I'm just sort of talking about the same work that was allegedly done by this individual who doesn't have a license. Did he just take it and photocopy it on someone else's license, and this contractor then puts it into the contractor board, and the same alleged work, I guess it'd still be a violation of some sort. I mean, obviously, I'm just wondering if that's something that we should even try to shag that down to see if how that contractor was issued a license and by whose review report that was used for that.
Oh, so there was no license issued?
Yeah, right?
It was rejected.
Okay, so they've not retried, I guess?
No,
or do we know?
no.
Okay, thank you.
I mean, I'm thinking through, Brad, your very, good observation, and, we're already basically seeking a civil penalty at the maximum dollar amount that can be levied for the known violations that we have. And so I'm not sure what else we could do. There may well be other ramifications if these reports have gone out and were inappropriately relied upon by other parties. But basically, the way that we're constructing and have constructed our civil penalty requests and settlement discussions has been on the basis of the violation is the issuance of the report, period.
Yes, no, I don't disagree. Mine was more one for the record.
Yeah,
Should the record stipulate that this board, and I'm not going to come up right now with the actual language, but I'm suggesting, should we consider for this case and all others that our record should stipulate that the review report, and I'm using that in air quotes because it is not actually a review report, but nonetheless should be rescinded, or we deem it invalid and therefore it should be, again, it's not, I don't know how we would police that, right? Other than it, but the record would at least stand in this case, potentially, if it was referred to law enforcement, whether or not that's district or the state attorneys general, if they found that the report was still being used for whatever reasons, then that would potentially be another thing that they could latch onto if they decided to pursue this or similar cases in the future from a from a criminal perspective.
Yeah, I think that's a fair point. I'm not aware historically that we have ever directed, an issuer to rescind a report, in this context or any other. But it would be interesting to see if we had the authority to do that. And I guess what I would propose is that we allow counsel to research that, not necessarily having that research completed by tomorrow when we take action on the case, but at least for future cases that we become aware of that. And if we want to or need to go back and revisit this one, we can, to see if that is within our authority to require.
Yes, sir, I'll be glad to.
Okay. Brad, are you comfortable with that?
Yes, that's great. Thank you.
Okay. All right, so to recap, what we have going on this case, item number 13, is we're going to seek authority we'll request compliance with formal proceedings against respondent and authority to settle the case via consent order with a civil penalty of $5,000, consisting of $1,000 for each of the above described violations as referenced in the code or the board rule. And also that we will direct counsel to refer this case to the State Attorney General's office and appropriate local law enforcement officials for further follow-up, and that we will require the respondent to personally appear before the board if that respondent requests reinstatement, and if so, we would require the completion of the NASBA 3-section ethics course. I think I've got that consistent with what we had discussed. Any other comments or questions on this one? All right, we'll go ahead and proceed on to number 14. This is also Contractors Licensing Board referral. The wrinkle here is that there was a lack of independence on the part of the person that was completing the review report. She worked, I think, with respect to the private company. She's employed by the private company that was the subject of the review report. And so essentially we have a lack of independence, and we have a lack of a firm permit, although it's a little bit funky here because the report was for a private company. This was not for a CPA firm. So the recommendation here is to authorize formal charges for violations of code as specified in a settlement offer via consent order with a $1,500 civil penalty consisting of $500 penalty for violation of Tennessee Code 62-1-113 and a $750 penalty for violation of 0020-403 C8 and a $250 penalty for violation of rules and regs 0020-0308. Just an interesting case because of the independence ramifications that add to this. Any comments or questions on this one? We'll proceed on to item 15. This is another case where a review report was issued by a firm that had no firm permit and no peer review, and the standard discipline is being recommended here, which are to authorize formal charges for violations of code as listed and a settlement offer via consent order with a $1,750 civil penalty. That's pretty standard discipline for this type of an episode. Item 16, similarly, we have a review report issued without a peer review. However, in this case, the firm did have a firm permit. So the recommendation is to authorize formal charges for a violation of 020-403C8 and a settlement offer via consent order with a $1,000 civil penalty. Item 17, similarly, is a review report issuance, no firm permit, and no peer review. So the recommendation is for a total $1,700 civil penalty and to authorize formal charges for violations and a settlement offer via consent order with a $1,750 civil penalty. Item 18 and 19 are linked together. The first item, 18, is a complaint with respect to the individual licensee. So what, excuse me, what we have is a review report with no firm permit and no peer review. And the recommendation here with respect to the individual is for a $1,500 civil penalty consisting of $750 for violating the peer review and $750 for violating the firm permit. However, it is noted that in this particular case, the mitigating factors were remorse expressed by the individual here in this particular case. So that's what we have against the individual. And then in case 19, this is a complaint opened against the firm entity itself. And this basically has the standard penalty. So authorize formal charges for violations of the code and a settlement offer via a consent order with a $1,750 civil penalty, which would be standard for the violation for peer review and violation for firm permit. Any questions on these two cases? The first, number 18 is the individual involved, and number 19 is the firm. Okay, we'll go to number 20. This is our last proposed discipline case. This is not a referral by the Contractors Licensing Board, but it is one from the Comptroller of Treasury. The respondent issued an audit report to the Comptroller. It was unable to verify an active permit or enrollment in peer review. The board opened the case, and upon investigation, the firm indicated that its firm permit had expired. They acknowledged taking some steps in the peer review program, but they were ultimately terminated from that program in September of 2024. And so the firm was removed from the peer review program at that time. In this particular case, the recommendation is to authorize formal charges for violations of code and law and respondent's prior consent order entered on August 8th, and 2, a settlement thereof via consent order with a civil penalty in the amount of $3,000 calculated as at $1,000 per violation, and a consent order to include cease and desist language specifically prohibiting auditing or attest services to be performed by the firm. Any questions on this particular case? Hearing none, we'll go ahead and proceed to vote on the recommendations as discussed on the proposed discipline cases, items numbers 12 through 20. Is there a motion to approve?
I'll make a motion.
We have a motion by Mr. Bonner. Is there a second? Seconded by Mr. Floyd. Is there any further comment or discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed, say nay. That motion passes, and before I turn the meeting back over to our chairman, I just would also like to just offer thanks to Jen and staff and to council and to our investigator for the work that went into these cases and those that you have coming up. It's important that we do this to try to protect the investing public, and just appreciate all of your work in terms of doing that. And we'll look forward to final adjudication tomorrow at the board meeting. Mr. Chairman, I'll turn it over to you.
Thank you very much, Mr. Monroe. And you sank that birdie putt on number 18 at the Masters, so congratulations.
Thank you.
Jen, do you think maybe 10 minutes is what we need for the executive report?
Yes.
So my question is, does anyone need a break, or should we spend 10 more minutes? Okay. Okay.
All right, I'll make it quick.
Committee members, could I interject here on the phone? This is Michael Montgomery. I joined the meeting a bit late, but regarding the credit extension, the first line item on folks' agendas, I was just wondering if there was a conclusion reached there that could be revisited here.
Would you mind, Mr. Montgomery, if we hold public comment until the end of the meeting? I'm not sure where to look, but hold that until the end of the meeting.
Yeah, that's not a problem at all.
Okay,
Thank y'all so
thank
much.
you.
Sorry for the interjection.
Oh,
Yep.
you're good. Thank you. All right. Okay, we can go through this pretty quickly. So
Great.
you have two attachments for the executive committee. The first is travel detail by board staff from Q1. So you'll see mine and Duke's trips to Clearwater, Florida for NASBA's annual conference for board staff and legal counsel. We'll hear more about that tomorrow. And those, I'll note too that those amounts that you see there do include the conference fees as well. So part of that is education expense, as well as Duke's travel to Nashville for the February board meeting. The second document is our financial statements through the end of March, so 3/4 of the way through the fiscal year. And what I'll point out here is this includes, these top lines revenue include the bulk of our renewal revenue. We do expect to continue to see some of that trickle in through the end of June when licenses go from expired grace to just expired. But I will say, in general, my take on this is that specifically with our admin cost backs, which includes legal, centralized complaints, customer service, and then our admin cost backs, I would say we are trending favorably to budget. Revenue is trending about where we planned it to be for this time of year. So I do think, I hope this is not premature to say, but I do think that we will still continue to operate in a deficit this year, but I don't think that it will be as great as perhaps we had planned it to be. So I'm happy to take any questions on that.
Questions? I did commend Jen personally, but I will do it publicly for attending the NASBA conference for EDs and board staff. And Duke, also thank you for attending. I serve on the Enforcement Resources Committee of NASBA, and we reviewed the agendas for those meetings, and very good information. And so thank you both for attending those meetings. Any questions for Jen? I know I asked that, but none? Rob, you look like you had one, maybe some. Sorry. Okay. So we will move to the public comments section, and I think we have a question, maybe.
Yes, Mr. Montgomery, you're welcome to speak.
Yes, absolutely. Sorry, I joined the meeting a few minutes late here. But as far as that credit extension request there for M. Montgomery listed as the first item under licensing, was curious of the committee members' initial response.
Shall I respond, or do you want to? Or go ahead.
Hi, I'm Pam Church, and I am chair of the relevant committee, the licensing committee. And we did consider your request. Just to remind everyone, Mr. Montgomery is the one who had changed due to a furlough from his original intent of working for a CPA firm. He had changed to investment banking, and that was in the middle of COVID, and we talked about that was certainly an unusual time. And you had asked that that be considered as an undue hardship beyond your control, and had asked to approve an extension for Reg and BEC from an expiration date of 6/30/25 to 12/31/25. Understand, this was only the committee's consideration, and it will come before the full board tomorrow. But the committee did vote and will recommend approval of your request. So we
Thank you,
will
Dr. Church, and thank you,
find out
committee members,
tomorrow
for the
what
consideration.
Sure.
Great, thank you so much.
Thank you for being
Yeah,
here.
I appreciate that. And if there's any additional information I can provide, I'm happy to do so. But again, thank you for the
after-
consideration.
I mean, you're welcome to watch the online discussion that will be posted after tomorrow. I don't know, it's posted in a few days, but there were not any specific questions beyond what you had provided.
Thank you so much.
Sure.
Very good. Karen, do we have others who want to participate?
No, sir, we don't.
Great. Okay. I will ask board members to do just a little homework. and that is to review the email that Jen sent us last week that I think was forwarded maybe from John Johnson of NASBA regarding some legislation that's being proposed in Florida, and that's very important. It could affect how we treat licensees from Florida and other states if other similar legislation is introduced. So if you have time tonight, just review that information, familiarize yourself with it, and we'll discuss some of it tomorrow. Anything else that members, Jen? Okay, thank you. We are dismissed, and we will see you tomorrow. Okay. And thank you.